Good morning, and thank you for you all and to the Exodus Dignity Network for giving the International Air Transport Association the opportunity to speak with you on the very important topic of human trafficking, whether as a tool to support illegal migration or for the darker purposes of exploitation. My name is Carolina Ramirez, and I am IATA's Global Director for Aviation Security and Facilitation. In this role, I am responsible for developing IATA's responses to critical issues such as these in cooperation with our member airlines and other critical governmental and non-governmental stakeholders. These efforts date back nearly 20 years with respect to control of illegal migration, but are much more recent in respect of efforts to control the movements of women and children traveling under duress. Regardless of the purpose of trafficking, whether for illegal migration or for human exploitation, the role of international airlines will remain largely the same. The limitations in what those airlines will be able to do and what they simply cannot do will continue to be consistent for the most part, regardless of where the movement in question occurs. In essence, airlines themselves have very little power or legal authority to prevent the movement of persons across international borders by or for human traffickers. Instead, our international airline members can only respond to obvious violations of requirements established by states relating to criteria under which a specific individual will be allowed to depart from or enter into a given state. Typically, this will be limited to the airline, establishing that the individual in question is in possession of appropriate travel documentation. For example, a valid passport or other required document of identity, a valid visa, if such is required based on nationality and stated purpose of travel, and additional supporting documents if the traveler is a minor child or traveling to or from a state having such additional requirements. That the documentation is legally issued and was issued to the person presenting for international travel. Airline check-in staff are experienced in checking documentation for the purpose of preventing the movement of persons seeking to avoid detection for purposes of illegal migration, which represents, in our case, the vast majority of those being trafficked on a global basis. Airlines today identify the majority of such persons at origin, like the example you gave, on a global basis, preventing their planned movement. Where the airlines fail, typically immigration officials at the intended destination identify the discrepancies and halt and stop the illegal movement. Far more difficult, though, and typically beyond an airline's ability to control, are movements for the purpose of human exploitation. In most cases that we have investigated, the individual being trafficked does possess the necessary documents. In most instances, the individual goes along with the movement because he or she assumes that the flight will lead to a better life. In others, the individual being trafficked is being coerced and will give few outward indications of concern. A person appearing anxious, awaiting a flight, may simply be nervous or angry, and not somebody who is being forced to travel for illicit reasons. Airline staff, then whether on the ground or in the aircraft cabin during the flight, are simply not experts in human behavior. Neither do they have the legal authority to stop individuals as they pass through an airport or as they board an aircraft destined to another country. Instead, they are more and more being encouraged to become aware of situations where something does not seem quite right, and to report those situations to superiors for possible follow-up. With respect to individuals for whom some concern may exist that human trafficking may be involved, several states have developed voluntary cooperative programs with airlines and other transport operators. In the United States, the Department of Homeland Security introduced its Project Blue Lightning in 2010, which encourages airline staff to be aware of potential problems and, when noted, to report those to the appropriate authorities who do have the legal justification to support a more intensive intervention. Those airlines participating in the Blue Lightning program have received specialized training for their customer contact personnel that helps to identify those who might be at risk and how to best to communicate those concerns to the appropriate authorities. The United Kingdom and South Africa have also developed and implemented specific procedures and policies relating to the movement of minor children. While these procedures assign specific roles and responsibilities for airlines, they are largely tied to ensuring appropriate state-issued documentation is at hand. Effectively, those programs recognized that the state has the prime responsibility in seeking to end human trafficking and that airlines and other transport operators have only a supporting role. Our airline members have long displayed a strong willingness to support states in efforts to prevent the illegal movement of persons for illicit purposes. Where states have introduced voluntary programs seeking to identify and reduce such travel, airlines, for the most part, had taken on the additional responsibilities on a voluntary basis. However, that doesn't mean that airlines have any willingness or legal ability to take on roles and responsibilities that normally require law enforcement powers. Airlines can only respond to the requirements that they check for necessary official travel documents. Where an airline believes that an inappropriate situation has been identified that falls outside of a required document discrepancy, he or she cannot take direct action to stop travel. Instead, that agent can only raise the concern internally through local management up to the point where it can be conveyed to the appropriate local authorities for an official response. And we just saw in the previous presentation how the links between the airlines and the local officers is a collaborative one, as you just stated, Mr. John. So today, we recognize human trafficking to be a global concern, impacting on the lives of thousands of men, women, and children. IATA member airlines do and will continue doing what they can to help identify and prevent the illegal movement of persons deemed to be at risk. However, that direct airline industry assistance and involvement must be seen as limited in scope. Instead, we believe that this issue is inherently one calling out for a global political solution. A solution under which states from around the world can agree on a common policy position, common goals, and objectives, and ultimately a common set of responses, both for the states and for the airlines that serve their airports. Thank you.
Okay, thank you very much, Mrs. Ramirez Taborda, for this introducing speech. We have questions, I am sure, for you. Now, I would like to give the floor to Madame Anja Klug, qui est donc directrice du bureau suisse au HCR, donc au Haut Commissariat pour les réfugiés. Madame Klug, je vous donne la parole.
Merci, monsieur, et merci tout d'abord pour l'organisation de cette conférence importante et merci beaucoup à monsieur Oté pour avoir invité l'HCR de participer à la conférence. J'aimerais faire ma intervention en anglais parce que ça me permet d'être plus précis dans mes mots et dans l'explication. The topic, my presentation has 3 parts. Monsieur Oté has asked me to talk a little bit more generally about border control and human rights and refugee protection. Then I would like to draw your attention to some very specific border control measures which are more linked to the arrival by planes. And then I would like to discuss with you a little bit whether they are in line with international law. So I would like, my presentation will very much focus on the legal framework in which border control takes place. We have already heard a little bit from Monsieur Jäger about this point, so I will base on what he has already told you in his first intervention, but elaborate a little bit further from the perspective of refugee law. Starting point is, of course, that it is under international law a sovereign right of states to choose whether they want to admit a non-national to their territory. And of course, we all must not acknowledge that there are some very legitimate interests of a state why they undertake border control, and I'm sure you are very much concerned about that, is to prevent terrorism, to prevent criminal activities, and to protect citizens against uncontrolled migration. However, this right of states is not without limitations. We have already heard about this, from limitations from certainly also national law, but I will of course focus on those deriving from international law, and I focus on those deriving from international refugee and human rights law. The most important in this respect, Monsieur Jäger has already mentioned the principle of non-refoulement, the prohibition to return a person to a territory where he or she may face persecution or any other irreparable harm. The first expression of this principle is in the 1951 Convention on the Rights of Refugees, but then we have numerous international human rights treaties that also include this right, and of course, very importantly, the European Convention on Human Rights, Article 3, the court has also developed a protection against refoulement from this provision. It's also important that states not only have to respect the right of to protect people against refoulement, but there are numerous other human rights that states have to protect, relating to the treatment of people at the border, relating to specific needs certain people at the border may have. This sounds very, I think it sounds very basic to you, but what we see nowadays in Europe, not necessarily in Switzerland though, is that even those very basic principles are violated on a daily basis, where we see pushback operations taking place, where people are pushed back from the border of a state without any examination whether such measures may result in a violation of the principle of non-refoulement, and even less sophisticated, we have a lot of reports about people of border guards. I have to underline once more, I'm not talking about Switzerland, talking about border guards in other countries, in Greece, in Bulgaria, where we have reports of people who have been bitten by dogs, who have been beaten up, or where border guards somehow seem to be involved also of stealing property from people who come. All the non-refoulement principle and obviously all other human rights obligations apply to all state agents, to border guards, to any state agent in the country and also at the border, not only within the territory of a state. And we have already heard before, non-refoulement protection does not only apply where people are directly brought back to a country where they face such dangers, but also if such risk, when there is a risk of an indirect refoulement through another state. These obligations under international law, under European human rights law, are also recognized in numerous national laws, in Swiss law, in other national laws of European countries, and they are also can be found in several instruments of EU law. One of the more important ones directly concerned with border guards is the Schengen Border Code, which is also applicable to Switzerland because Switzerland is not part of the European Union, but we have heard before that it is part of the so-called Schengen acquis. What I think, I mean, there are lots of interesting documents and papers and discussions about the rights and the obligations states have at the border. What I find really important is to stress from our perspective and our practical work with border guards and also my discussions I had with many border guards is that it is very easy to put these obligations forward. It is much more difficult to implement them in practice. It is a very challenging task for states to try to combine the requirements and responsibilities the state has towards protection of its citizens, and on the other hand, the requirements and obligations a state has towards people who want to enter their territory. We have been working a lot as UNHCR to try to develop tools on trying to make this task easier for border guards, and I will talk about this a little bit in the last part of my presentation. What I've just presented to you, the need to respect human rights and refugee rights at the border, is a discussion which is going on for many years. I mean, this is not anything new, but what we see, what is new, and that there are developments on how border control takes place nowadays. And I know that Monsieur Otte, he is very aware of this, but I often have the feeling when talking to an audience that is less experienced, that this is not really something which is very much known in the broader public. And that most of the discussion is still very much focusing on the actual territorial border. What we see as some of developments that have taken place during the last 10, 15 years, I have to say, is that some states try to distance themselves of these obligations they have under international law by a number of measures that can be problematic depending on how they are applied. One of those measures is that the declaration of certain zones to be outside a state's territory. Let's say, you arrive at the border and the border area is declared not to be forming part of a state's territory, with, the obvious reason that the rights and the obligations a state normally has don't apply as this. Then what we also see that interception measures, I mean, people being stopped to continue their movements are not only taking place at the actual border, but they are applied further and further away from the actual border. Monsieur Jäger has already talked about the sea, the high seas, but they are also taking place in the territory of third states. We have heard about the airline liaison officers, which are an instrument of states to intercept people before even coming to a territory. We also see that interception measures are sometimes delegated to third states. I mean, third states, there are negotiate contracts with third states to undertake border control measures to prevent people from leaving their territory if they don't have the necessary documentation to travel on. And I mean, you have talked about this. We are very much focused on human trafficking, but we also see that some functions related to border control are delegated to private actors, airlines, ship lines, or other companies. We will look into this into more detail. It's, I would like to go through some of these measures. I don't think we have the time to go through everything. I will talk a little bit about two themes which I find very important, namely the extraterritorial control measures and the delegation of border control functions to private actors. Why are these the extraterritorial measures? Why are they, or why can they be problematic? I mean, one area which I think is of great concern to us as UNHCR is that it is very little is known about how this, what exactly, I mean, that's why it was very important to hear your presentation, how airline officers really work in practice. There are very little monitoring mechanisms in place extraterritorially because it's, of course, it's very, very difficult. It's even more difficult for border control measures taking place on the high seas because, I mean, UNHCR NGOs are normally not on the boat next to what is happening. So we don't know enough on what is actually how these measures are applied. And secondly, they give rise to a number of legal questions. And to what exactly is the applicable legal framework? Our position is that Article 33 of the 1951 Convention, the non-refoulement principle, is not limited to a state's territory. Our position is that states have to respect Article 33 wherever they have jurisdiction. This is very much based on human rights law, which has been developed on this point. Mr. Jäger, again, I can refer to his explanations in his introductory presentation, has already outlined the position of the European Court of Human Rights, but there are other human rights bodies that have equally developed this position that human rights law is applicable even outside a state's territory when the state has jurisdiction. According to the European Court of Human Rights, it means if a state has effective de jure or de facto control. And while it was the European Court, because that's the court most important for us here in Europe, has been very restrictive initially on how in its examination when such a jurisdiction, when such an effective de jure or de facto control was there. As already outlined by Mr. Jäger, there seems to be a growing tendency by the court, but also by the other human rights bodies, to basically agree that such a jurisdiction is there whenever the state exercises acts, and basically in the whenever the state acts through its agent, it is basically responsible for the effects of these actions. It's important to say that the responsibility for human rights violations or for the respect, let's put it positively, for the respect of human rights obligations and obligations under refugee law apply to the state that acts extraterritorially, but when these activities take place on the territory of another state, like for example, if we have a border official working in a third state, then there is additionally, of course, can be a responsibility of the state on whose territory the immigration control takes place. I want to continue with the second point I wanted to make, the second area where I think it's important to look at, namely where border control measures are delegated to private actors, carriers. I mean, we know that you haven't mentioned this because you have been focusing on human trafficking aspects, but since the 1990s, carriers are sanctioned if they bring people into the territory of a state, and it applies to airlines as well as to other transport companies, if they don't have the necessary documentation to enter that country. The question is, I mean, you have outlined very much for the area of human trafficking that your responsibilities and the possibility what you can do is limited, and I'm sure you would have told us a little bit the same if it comes to the question of deciding or differentiating whether somebody needs international protection and needs to have basically a different needs to be brought into the country even though he or she doesn't have the required documentation. The question for me is also, I mean, I would like to draw your attention to is less, the responsibility of the carriers. For me, the question is the responsibility of a state obliging a carrier to control, not only control, but to prevent people without documentation to enter a plane. Again, back to what I said at the very beginning, in general, of course, states have the sovereign right to decide whom they want to let on their territory. So, of course, there's nothing we can say from the perspective of international law if somebody who doesn't have the required documentation is prevented from boarding a plane. But there are, as I outlined in the beginning, there are some limitations. And the question is whether these limitations also apply when somebody else acts and not only the state. So far, we don't have a lot of decisions, international case law on this question, but there are some norms in international law that and some customary international law that looks at the question of state responsibility. And in these set of norms that have been drawn up, there are also some provisions relating to state responsibility for the act of private actors, which clarify that that a state can, under certain conditions, be made responsible for the act of private actors. What are the conclusions or recommendations or suggestions I would like to make? As I mentioned before, border control is legitimate, but of course needs to respect international law. We have said the obligation exists not only where a state acts on its territory, but also outside, and even maybe when under certain conditions when such functions are delegated to private actors. But to ensure that these obligations are adhered to in practice, we think as UNHCR, I mean, it's not sufficient to draw attention to these international law principles. We have to work on specific protection safeguards, which start from having the appropriate legal framework in national law, because that's often the starting point. And it needs to be the legal framework relevant for border guards, because border guards, even those at the senior level, not necessarily will look into the asylum law, because it's in a different area of this law. And there need to be very concrete guidelines on how border guards need to apply these obligations in practice. Border guards, of course, need to know about the obligations, and what is even more important, and it's very difficult, they need to be given tools that help them to apply these obligations in practice. I mean, clear instructions, they have to know about the instructions, and they have to have tools to apply these in practice, such as, for example, lists with questions that help them to decide whether this is a case which requires a different treatment, or a possibility to contact somebody with expertise in the area of asylum and human rights law if a case becomes more complicated. As regards measures and border control measures that take place outside a state's territory, I mean, you have said that your role is not to prevent migration, it's to control documents. My question is, what happens? How do you deal with cases? Maybe you can explain to us a little bit later. What happens to you if somebody comes without documentation that tells you, I need to apply, I'm fleeing persecution, I need to apply for asylum? Do you have specific instructions on how to deal with such exceptional cases? I'm sure that this is not the majority of people that you are confronted with. But what happens? Do you have guidelines on these? Are there the possibility to refer these people to competent authorities, either if this is appropriate in the country where they are, because it's not necessarily the best solution, of course, or the only solution to bring them to Switzerland. But I'm sure, I mean, there may be some situations where indeed the only appropriate action to prevent refoulement could be to let them board a plane even if they don't have the documentation. Or do you have the possibility to refer them to an embassy? I mean, I know about some practices of other countries where such airline officers have a hotline to the asylum authorities where they can call in specific cases to seek further guidance on how to treat people. We see that some of these practices, some of such models exist, but they're very rare. I don't know about a lot. And I think it would be very important to further work on such very practical tools to allow border officials, because most border officials with whom I have talked wanted to respect these obligations, but oftentimes they didn't have the framework to act according to international law obligations. So give them, I mean, how we can give them, what kind of tools and what kind of mechanisms can be developed to allow border guards to fulfill these functions, to fulfill both functions at the same time. My last point I want to make is the role of civil society. For us, as UNHCR, civil society has a very important role with regard to protecting human rights and refugee rights at the border, be it in country or even if it's further away, to ensure that what we say as UNHCR, that border control is protection sensitive. In some countries, border guards have specific agreements with civil society actors and UNHCR under these sort of frameworks, I mean, where civil society basically, on the one hand, supports border guards with, developing tools and providing guidance on how to treat, differentiate between different kinds of people who come, but also with regard to monitoring on what is going on, what is the reality on the ground, and what are basically issues that need to be brought up to the attention, which need to be discussed, and for which solutions need to be found. this is a very important role, and I know that Monsieur Otte has been working on this a lot. I think I mean, as regards the topic of my presentation, it's even more important. I think too little work has yet been done to discuss how civil society and NGOs can fulfill this role, even, you know, even for activities that don't take place within the territory of a state, but outside the territory. I don't know, would be interested to hear from you whether you had any discussions with Swiss Border Guard on these basically part of their work, which is not taking place in Switzerland, but outside the country. Thank you.